Good afternoon.
Good afternoon.
Hello, Judge.
I'm missing someone they expected to be here. I think this is probably everybody. The Department of Family and Protective Services versus Apolonio Rodriguez in the 454 Judicial District Court of Medina County. Court is broadcasting remotely due to closures and the weather via Zoom and YouTube. Ms. Kyler Green, would you please begin the announcement?
Yes, Your Honor. Good afternoon. Emily Kyler Green, attorney for the department.
Hi, Irina Costa. For the mother, I'm not ready. I haven't had contact with her, and I'm not sure whether or not she's been served.
Mark Bram, attorney ad litem, ready.
Crystal Rosales, investigator with the department.
Alexandra Vanderbilt, Ibis Rosales is supervisor.
All right, thank you. Has mom been served? I don't show it in my system.
She is not, Your Honor. It's gone out and it was returned with no service.
Okay, I know we had anticipated that that might be the case from the time announcement last week, but I just wasn't sure if maybe a return and come back. Well, in that case, I would grant Ms. Acosta's not ready. We don't have service. We really can't enter any orders anyways. So, Ms. Greenlee, what do we have as far as a reset date on this?
Our next Medina date is not until February the 11th. And that is a pretty stacked docket. We could set it either at 9 or 2:30.
Either time works for me, Your Honor.
Is there any problem with, does the department have any issue if we wait until the 11th of February?
No, I don't. Oh, sorry. Go ahead.
No, that's fine with me, Crystal, if you answer.
I think we're good with waiting.
Okay. Well, the way I'm looking at it is it's more time to effectuate service if she's hard to find. But if I was thinking we might need to do something sooner, but if the department is okay, it's your petition. If you're okay with waiting till the 11th, then that's fine. Miss Greenlee's telling me that we also have a Uvalde Day on the 6th.
Your Honor, we could do the 11th, the 6th. We will be at a program meeting. So the 11th would also give us more time for service on this mother.
Okay, then we'll reset to the 11th. Miss Greenlee, what time did you say it was?
I said either 9 o'clock or 2:30.
Let's do the 2:30 because I know if I say 9 o'clock, I'm going to have some issue getting to Medina that morning, and I'll probably be late. So let's keep our 9:30 start, and we'll do. You said 2 o'clock or 2:30?
2:30.
2:30. Sorry, I can't keep it all straight right now. All right. So again, I'm granting Miss Acosta's not ready. We will reset to February the 11th at 2:30.
Thank you.
Thank you. If nothing further, thank you all for your time and your service. All parties are excused.
Thank you, Judge.
Thank you.
Good afternoon.
Good afternoon.
Good afternoon.
454th Judicial District Court of Medina County, Texas. Court is broadcasting due to weather closures from outside of Medina County via Zoom and YouTube. Ms. Kyler Green, would you please begin the announcements?
Good afternoon. Emily Kyler Green, attorney for the department.
Bradley Sherrod Buckner, permanency specialist for the case.
Christika Knopp, belong permanency supervisor.
Marco Cabrera, I represent respondent mother, Ms. Shauna Thompson. She's present. We're ready. Ms. Thompson, can you unmute and state your name?
My name is Shauna Thompson. I'm Princeton's mother.
Richard Salver, attorney for the father, Mr. Senegal. Mr. Senegal, will you unmute and announce, please?
Mr. Senegal, if you could hit *6 to unmute, please. Oh, he's trying to log in again, so I think he may be having an issue.
Tyler Senegal, the Christian father.
Irene Acosta for the child. I'm ready.
Anyone who's not an attorney or will be giving testimony, please raise your right hand. That includes both parents. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. All right, we are set today for a final trial. My understanding is the parties do have a mediated settlement agreement. Is that correct, Ms. Kyler Green?
That is correct, Your Honor.
All right, and what's the intention with the mediated settlement agreement as far as today is concerned?
Well, we'd like to put the MSA forward. We'll read it into the record. And then the department has 15 exhibits. All have been provided to the parties except for the order to retain. That one I did not send out an email. All are certified copies. And to my understanding, there are no objections.
Okay. Does anybody else have any other attorneys have any other procedure in mind as far as today is concerned?
No, Your Honor.
No, Your Honor.
Okay. Then why don't we go ahead and get your exhibits listed on the record, Ms. Kyler Green?
Yes, Your Honor. Petitioner's Exhibit 1 is the citation return for the mother. Petitioner Exhibit 2 is citation return for the father. 3 is temporary orders. 4 is the status hearing. 5 is the family plans of service. 6 is the initial permanency hearing. 7.
Slow down
Yes,
just a little bit. It's all right. I'm trying to keep up with you. 5 was what was 5?
The family plans of service.
Okay, and then 6?
Initial perm.
All right, thank you.
7 is the permanency review before final order from January 9th, 2024. 8 is the permanency review April 9th, 2024. Petitioner's Exhibit 9 is permanency review before final order July 16th, 2024. 10 is the order to retain. 11 is the permanency review October 29th, 2024. And 12 permanency review is 11/14/2023. 13 is the CCJ letter. 14 is the mediated settlement agreement. And 15 is the order adjudicating parentage.
Okay. And you're asking to admit all of these at this time?
I am, Your Honor. And I've got the CCJ letter if you'd like to see that, as well as the MSA ready for screen share.
All right, screen share has been enabled. Are there any objections to the exhibits 1 through 14?
No, Judge.
No,
No,
Judge.
Your Honor.
All right, exhibits 1 through 14 are admitted.
Thank you, Your Honor. Would you like to see the CCJ letter, or is it not necessary?
Let's go through the MSA and then I'll take a look at it. Oh, well, actually,
Okay.
if you have it right there, I can just take care of it real quick. Thank you.
Thank you, Your Honor. And this is Petitioner's Exhibit 14, the MSA.
You can go ahead.
Okay, thank you. On January 15th, 2025, all parties listed below agree to the following, being in the best interest of the child. Number 1, mother is appointed sole managing conservator, father is appointed possessory conservator. Number 2, father shall have supervised possession of the child on the first, third, and fifth Saturday of the month from 12 p.m. to 6 p.m., supervised by Shelley Castellanos, or children's matter at father's expense if Shelley Castellanos is not available. Number 3, father shall pay child support of $231.31 starting on February 1st, 2025, and on the first day of the month thereafter. Number 4, mother shall provide Medicaid for the, let's just say child, and father shall reimburse $25 a month for child support starting on February 1st, 2025, and on the first day of every month thereafter. Number 5, mother can request random drug tests from the father, and father has to take a test within 24 hours of request at father's expense. If he fails to take the test or test positive, his supervised visit shall be canceled until he can pass a drug test. Number 6, DFPS and all attorneys are dismissed. And it was signed by all parties.
Okay, thank you.
Thank you.
Are you requesting relief today?
No, we're not.
Okay. Mr. Cabrera, that's your understanding of the agreement.
Yes, Your Honor, it is. And we've agreed to those terms.
Mr. Salazar,
Same announcement, Judge. It's our agreement, and we agreed to the mediated settlement agreement.
Ms. Acosta.
Yes, Your Honor, that's my understanding of the agreement.
Okay. And then we don't have a CASA on this case, I don't believe. Ms. Thompson, can you unmute for me, please?
Yes, sir.
All right, this agreement is, you had the opportunity to discuss it with your attorney,
Yes.
and you understand what the agreement, what rights and duties it gives you.
Yes.
All right. Were you forced to enter into this agreement in any way?
No.
And this is your voluntary agreement. You weren't made any promises or inducements to get you to agree to it.
No.
Are you asking me to approve the agreement today?
Yes.
Okay. Thank you. Mr. Senegal, same questions for you. Is this the agreement that you made?
Yes, Your Honor.
Did you have the opportunity to discuss it with your attorney?
Yes, sir.
You understand what rights and duties it gives you?
Yes, sir.
And were you forced to enter into it in any way?
No, Your Honor.
Were you made any promises or inducements to get you to agree to it?
No, sir.
Are you asking me to approve this agreement today?
Yes, Your Honor.
All right. I don't know, Ms. Kyler Green, if you want to ask Ms. Sherrod Buckner just a few questions about why this agreement's in the best interest of the children, that might be good.
Yes, Your Honor. Thank you. Mr. Buckner, can you unmute? Thank you. What is your role in this case?
Permanency specialist
And how long have you been involved?
since the beginning of March of 2023.
Okay, thank you. Were you present for the mediation?
Yes, ma'am.
And have you also had an opportunity to spend time with mom and dad and the child throughout this case?
Yes, I have.
Okay, and do you understand the terms of the agreement?
Correct.
And where has the child been placed?
With mom
And since when?
since November of 2024.
And have you had an opportunity to observe mom and Princeton together since he's been placed there?
Yes, ma'am.
And this case had an extension, is that correct?
That is correct.
And what was the purpose of that extension?
That extension gave mom a little bit more time in the case since she was also doing her services. So we went into a transition and wanted to return.
And that started in November?
Yes, ma'am.
Okay. And do you think that mom is able to exercise a protective capacity over Princeton?
Yes, ma'am.
Okay. And have you been able to witness any bond between the two of them?
Yes, ma'am, I have.
In regards to the child support, do you think that that'll be beneficial for Ms. Thompson to receive that from Mr. Senegal?
Yes, ma'am.
Okay. Is she able to provide for Princeton?
Yes, ma'am, she has been.
Okay. And is the placement safe and appropriate, and are all of his needs met?
That is correct. Yes, ma'am.
Okay. How is he doing? Is he how are his medical and any sort of like psychological needs that he has?
He's doing really good. He does have an upcoming doctor's appointment and dental appointment on the 23rd. He has started engaging in counseling as of January the 9th, I do believe. He will be seeing a therapist there, but for play therapy on his appointment on the 23rd, we would need a new referral because we was not able to cross referrals from his previous placement. So once he get the new referral for OT, he'll be able to start OT services. Mom has been doing really good about communicating with me regarding Princeton's needs since we have entered the transition to monitor return. If she has any questions or she needs help seeking services, Mom has reached out to me, so I'm able to help her in that capacity.
Okay, does she understand that the department will be dismissed today and she will have to continue ensuring that he's engaging in all the services that he needs for his safety?
Yes, ma'am.
And do you think that she's capable of doing that?
Yes, ma'am.
Okay, and why do you think it's in Princeton's best interest to have his parents appointed in the conservatorship that they'll be appointed?
As of right now, since Princeton is currently placed with his mom, and she had continued to show us that she's able to do this by herself, we do believe that it's best for him to be placed with mom so they can continue to bond and she's able to continue to parent Princeton. But for dad, right now, since he does not live in Divide, he stays in Katy, that will also give him some type of parental capacity to be able to still see his son. And then with that, they're able to continue to have a bond as well.
Okay, and do you think that the parents will be able to co-parent effectively?
Yes, ma'am.
Okay, thank you. Your Honor, no further questions.
All right, Mr. Cabrera, you have any questions?
No, Your Honor, I don't.
Mr. Salazar,
I have no questions, Your Honor.
Ms. Acosta,
Just briefly, Your Honor. Ms. Sherrod Buckner, the supervised visitation that we agreed to for dad, that's for Princeton's protection, correct?
Yes.
And is that due to dad's substance abuse issues?
For this case, yes, ma'am.
Yes. And has mom demonstrated that she will be willing to be a protective parent in that capacity?
Yes, ma'am.
Okay, and she agreed to the supervised visits, correct?
That is correct. Yes, ma'am.
Okay, and Princeton has a sibling who's residing in the home with him, correct?
Yes.
Okay, so he'll get to continue bonding with that sibling with his mother, correct?
Yes, ma'am.
Okay. And Ms. Thompson has demonstrated that she has a support system able to assist her with the children, correct?
Yes, ma'am.
And is she able to demonstrate that she recognizes what community resources are available to her as well?
Yes, ma'am. To me, yes, she has.
Okay. And any issues that had been pointed out regarding the home or the surroundings, all of those issues have been resolved, correct?
Yes, ma'am. That is correct.
Okay, and Princeton is placed with her in a safe, stable home.
Yes.
Okay, I'll pass the witness, Your Honor.
anything else, Ms. Skylar Green?
No, Your Honor, thank you.
Okay, anybody else have anything? Okay, Ms. Acosta, is there anything else you wanted to add?
Just that, the real work is going to start when all of us are gone for Ms. Thompson. And I would just hope that in the future she reaches out to her support system and the resources that she's been able to identify to help if there are any issues moving forward. I think that the orders that we agreed to help put a framework in place that will keep Princeton protected. But that also is incumbent and contingent upon mom, following through with those orders and identifying supports that she needs moving forward.
Okay, thank you. Then, for the purposes of the final trial, court finds that the mediated settlement agreement of the parties is in the best interest of the child. The court will adopt and approve the mediated settlement agreement in all respects and order that the Department of Family and Protective Services / Belong be dismissed as the temporary managing conservator, and that the mother, Shauna Thompson, is appointed as the permanent managing conservator of the child, and that Mr. Senegal Tyler Senegal is appointed as a possessory conservator of the child. Visitation shall be according to the parameters in the mediated settlement agreement, which should be attached to the final order and included in that order as stated in the mediated settlement agreement and here on the record. And then same for child support. The court will find that it's in the best interest of the child for the child support to be set at $231.31, beginning, and that's payable by Mr. Senegal as the obligor. And that will begin February 1st, 2025, and continue thereafter on the first day of every month until further order of the court. Court will also order that the child be on Medicaid pursuant to the mother, and then Mr. Senegal will reimburse $25 a month for medical. The drug testing requirements that are in the mediated settlement agreement shall be incorporated into the final order as stated here on the record and in the agreement. Court will dismiss all the attorneys and their appointments and find that they have satisfactorily fulfilled their duties. And I think I've covered everything. I want to say to Ms. Thompson, really proud of you. Really proud of the work that you've done in this case. We've been at it for a while, and we've been at it for 22 months. So we've stuck through. I know it hasn't always been easy, and there have been some difficulties, but at the end of the day, your child is with you, and you're going to be the permanent managing conservator of your child. And as Ms. Acosta said, it's up to you. And then, of course, you have your support groups and the things that you've learned in this case. And I hope you rely on those things too. And Mr. Senegal, I really hope that the things that might still be concerns are you're able to deal with those things and have a meaningful relationship with your son as you move forward. But Ms. Thompson, I do want to give you a round of applause. I want to make sure that you understand that this is how these cases are supposed to end up. Your child's supposed to come home to you, and that's what's happening here. So I'm really happy to see that. Ms. Kyler Green, is there anything I've failed to address?
No, Your Honors. Thank you.
Okay, then that will be the order of the court. There'll be no further hearings. Thank you all for your time and your service. Ms. Thompson and Mr. Senegal, good luck to you both. Judicial District Court of Medina County, Texas. Court is broadcasting via Zoom and YouTube. Due to closures and the weather, Ms. Kyler Green, would you please begin the announcements?
Good afternoon, Emily Kyler Green, attorney for the department.
Alana Pearsall, attorney for the mother, ready.
Marco Cabrera, attorney for interveners, ready.
Christy Connaught, permanency supervisor with Belonged, Holly.
Holly Knipper Rose, permanency specialist.
Jennifer Harris, attorney for the respondent father, I'm ready.
Richard Slaughter, attorney for the child, ready.
Jill Roden, Tri-County CASA.
Anyone who's not an attorney or will be giving testimony, would you please raise your right hand? Do each of you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can put your hands down. All right, we're here today on the motion to strike. Is that correct?
Yes, Your Honor.
All right, it's your motion, correct, Ms. Pearsall?
Yes, it is.
Okay. Any housekeeping we need to take up before we begin?
No, Your Honor.
Parties waive opening, or do you want to give an opening statement?
Judge, it's just argument.
Okay.
I don't want to call any witness.
You're not going to call any witnesses?
No.
Okay, then go ahead.
Judge, if you look at the petition, it basically fails on its face. The only recitation for standing in that entire petition is a non-existent statute. It doesn't exist in the family code. If you assume they made a typo, just kind of by the language, and they're relying on the grandparent statute or the relative statute, they clearly fail under that as well. That section provides that you can intervene if the parents are deceased or if you are a relative within the third degree. These people are in no way related to the parents. There's absolutely zero biological relationship between them. If you look at this intervention, all 4 lines of it, 4 sentences of it, it also seems to be filed on behalf not of actually the interveners, but of the minor child. Texas law is very, very clear that a child under 18 cannot hire an attorney. It doesn't have capacity to bring a lawsuit. Additionally, Judge, this other child is a child that both of the parents in this case relinquished their rights to voluntarily in a private termination and adoption. And the law is very, very clear. And it's controlled by Texas Government Code 573.022 that once a child is adopted, a child is related to the adoptive parents, and specifically as far as determination of family relationship by consanguinity, and is in no way related to biological parents. And quite frankly, Judge, having even the suggestion that law can hold anything else goes against everything we do in this court and every termination of adoption. They clearly have no standing. So beside the fact that their intervention completely muddles the water and adds extra people with extra wishes, not that their intervention gives us a clue as to what it is they want, it doesn't, which is partially why it keeps muddling the waters. They clearly have no standing on their face. So I'm asking that their intervention be struck.
Thank you, Ms. Pierce. So I'm going to start with the department as far as we go down the line in order. Ms. Tyler Green.
Your Honor, the department does not have any objection to the intervention. And I don't think it's appropriate to provide any argument at this time.
Okay. Ms. Harris, what is your response?
Your Honor, I'm the attorney for interveners. If
right, but what I'm doing is I'm just going down the order of the. I mean, I guess it doesn't matter really.
My apologies. I'm sorry.
No, it's okay. I mean, I'm just looking at the order of parties that we normally follow. If the department's going to abstain, then I think in that situation, it probably wouldn't hurt and be out of order for you to go next. So let's go that way. Let me hear your response, Mr. Cooperdato, and then I'll hear from Ms. Harris and Mr. Saldivar.
Yes, Judge. So the Hammond family has the child Robert Wesley V. Now his parents are Angelica Hammond and Robert Hammond IV. Robert is the biological child of the respondents in this case, which they relinquished their rights to, and the Hammonds adopted. Now, there's a lot of moving parts here. If Ms. Pearsall is saying that Mr. and Mrs. Hammond do not have the right to seek intervention on behalf of their child, I believe that is incorrect. Now, the additional argument that she's making is that ties between their child, who is the biological child of Ms. Howes and Mr. Rapp, and the child the subject of the suit that relinquishment cuts all ties between those siblings. I know less about that, but I will say that is not the only means by which they have standing to intervene in this case. Should this court strike the intervention based on that, they have clear standing based on, let me read, section 102.005 subset 3 of the Texas Family Code provides that any adult who has actual possession for the actual possession and control of the child for not less than 2 months during a 3-month period preceding the filing of a petition has standing to intervene. Now, if the court does strike on 102.003, which I filed under, then we do have standing by other means. I would ask that the court not do that to save my clients a little bit of money. They are of limited means and are caretakers for the child the subject of this suit. My understanding is that the parents have not been compliant, and the Hammonds are just trying to find how to get through this case, being that they are not a foster family, they are a fictive family by means through their existing adopted child.
Okay, before we move on, let me ask a question. You said that your clients were seeking their relief based on standing per 103 or 102.003. Is that correct?
So I filed under 102.003A13. But there is also standing on 102.005 subsection 3, which I did not file for, but will if we are struck here today.
Okay.
And again, I can read that again. It's any adult who has possession or control for not less than 2 of the last 3 months preceding the filing.
Right. You're talking about the 102.005, correct?
Yes.
Okay. I'm looking at 102.003 if you're relying on that. And that's the consanguinity prong of the statute, correct?
Yes, Your Honor.
Okay. My understanding is that has a dependent clause, which is that the parents have to be deceased at the time of the filing of the petition, but that's not the case here, correct?
Correct.
Okay. I just want to make sure I've got everything straight. All right, Ms. Harris, what is your response?
Your Honor, the point of pleadings is for everybody to know exactly what the petitioners are seeking and why and what they're basing that on. And I think that, as Ms. Pearsall said, the face of these pleadings clearly do not establish grounds. Not only do the interveners not have the consanguinity requirement as pled, they also do not have the alternate pleading that they are now posing today, which is possession of the child prior to the filing of the petition. This child was in the possession of his parents until the removal of this case. These interveners did not have access to the child. Additionally, another consideration is whether it's going to cause unnecessary complication or duplication of issues when you have these interveners involved. The proposed interveners and the department are fully aligned. It is not going to harm them or prejudice them in any way to continue serving as placement and not be interveners in this case. It's, I think, an unfair advantage of parties ganging up on the parents in this case, especially when the initial goal is family reunification. So I think there's many grounds for the mother's petition motion to strike the intervention should be granted. No standing based in the pleadings, no standing in fact, and unnecessary duplication and complication of issues.
All right. Mr. Saldivar.
Judge, I mean, if Mr. Cabrera needs to amend his filings, I would just ask the court to instruct him to do that. If they find that it's not sufficient the way it's filed, we have a placement that has adopted a prior biological sibling to the child. We have a placement that has significant contact with the child, and I believe past significant contact as well. I think it's in the best interest of the child for them to be a party to this suit. Like again, they've adopted a sibling. They've had contact with this child before. This is not the first time the parents have been involved with the department. It doesn't change the fact that the parents have the opportunity to work the services and get their child back. We're just adding them as a party to the suit, Judge, because in the alternative, if the parents can't get their situation together, they're there and willing to adopt just like they adopted the biological sibling.
Okay.
May I respond, Your Honor?
Yes, give me just 1 second. Okay, go ahead, Mr. Song.
Your Honor, the only thing the court can consider in a motion to strike is a live pleading before the court. Mr. Cabrera and all the other parties have had over 21-day notice of this motion. If they wanted to acknowledge that their pleading was deficient, which basically Mr. Cabrera did in his argument today, he had plenty of time to amend it, and he didn't. And I will tell the court that if he goes through and the way he claimed he would today and file a brand new intervention, then I will file a motion to strike that as well, because the statutes that he claims he will rely on the future, which are not even being considered today, are for original petitions only, not for interventions. It's not a ground to intervene. And they're for termination and adoption lawsuits, which these are not. There's no pleadings for adoption in anybody's pleadings. But regardless, it's not even an issue that the court can consider today. The only thing that the court can consider today is whether his petition for intervention should be stricken or not, and it should clearly be stricken. He has no legal, honest ground to intervene. I mean, his pleadings have false on their face. His parents are alive. This child is in no way legally related to them.
Thank you, Mr. Song.
If I could respond, I know you're probably ready, but if I could just respond briefly.
That's fine, Mr. Cabrera.
There is a bit of case law on this. Case law specifically, I can send you the case law, just stating that any party that has standing to file an original petition under section 102.005 also has standing to intervene. That has been my understanding of case law, and I can send that to the court. Yeah, she's right. If the court does feel that I'm lacking on this, I can and will refile, but I would just ask the courts for permission to amend.
All right. So I have a couple of questions after hearing all the argument. What would be the original, or what would be the standing that your clients would rely on to file an original suit?
In an original suit, well, in this case, let me think.
My point being that based on the pleadings themselves, I do believe that they're deficient when it comes to establishing standing on the face for this particular case and the circumstances of the parties. I don't want to create any more work for anybody. So if you're going to rely on a statute that relies on another statute that allows for standing, were it to be an original suit, I would want to know upon what specific ground does the standing to file an original suit exist for your clients, if that makes sense. Because if it's there, it's there, but on the face of these pleadings, it's not there.
And it's not there, period, Judge, under any pleading. I mean, these cases are very specific, and there are prohibitions that eliminate original suits in these cases.
Right. And the other issue we have here is your client is placement, and whether or not they have standing to intervene in the suit does not have any impact on whether or not they remain placement. Those things are mutually exclusive. But the big issue here is whether or not standing exists. Also, what also plays here, plays into this situation is whether or not it would allow the court to better understand and make a decision for the best interest of the child. That's also part of this process. And if I don't have standing to get me there, then that's a non-issue. If I have standing to get me there, then I have to make the decision on whether or not allowing a party to remain in the case would help me to better understand the case and make a decision in the best interest of the child.
Judge,
I've got.
Judge, can I interrupt for a second? Can I have a breakout room with just the department and Mr. Cabrera?
Yeah, that'll be fine. We can take a quick recess.
Thank you.
All right, y'all had a moment to discuss anything that.
Your Honor, I apologize. I've had an opportunity to confer with the state and with Mr. Saldivar. I've also had time to look over case law, the statutes, and find the means by which I would have original standing. If the court wants to hear that now, I can kind of delve into that again.
Well, Judge, and as much as I appreciate Mr. Saldivar obviously doing Mr. Cabrera's job, that's one of the reasons. One, this makes this way too complex if they intervene. And two, it proves they lose nothing by not being part of the case. And three, it's not in his pleading, so it's not an option for today.
Yeah, I think the issue that we have here today, I think I would be going against the letter of the law if I were to rule in any other way at this point in time, because an intervention has to stand on the face of the pleadings, and there has to be standing there. So, I can appreciate your client's position, but I don't think I have any choice today but to deny or to grant the motion to strike the petition and intervention. And if you want to talk to your client, you want to replead, there's no prejudice. You can do that again. So I think that's the way we're going to have to go today. So that'll be the order of the court. I'm going to grant the motion to strike. Again, that has no bearing on placement, but I just don't have anything in front of me today that allows me to deny the motion to strike. I just don't have any other choice. So, Ms. Pearsall, if you prepare an order and circulate it for my signature, you don't need everybody else's signature. Just get it to me and I'll sign it. That'll be the order of the court. Thank you for your time and your service. All parties are excused. Have a good afternoon.
Thank you.
Yes.
Okay, Ms. Garza, you can hear me, correct?
Yes.
Okay, can you speak so I can see if I can hear you?
Well, can you hear me?
All right, do you have English or Spanish selected?
English? English?
Okay, well, for some reason your microphone's not working because everybody else can hear me and I can hear everybody else. So if you
No, we can hear you both.
Judge, we can hear her as well.
Okay, well, I don't know what's going on then. Everybody can still hear me though, right?
Yes.
So this Zoom interpretation function has never worked the way they say it's supposed to, but we'll soldier on. All right, court is broadcasting via Zoom and YouTube due to inclement weather concerns, and the 198th Judicial District Court having canceled their in-person proceedings today because they are a referring court. This court decided to also do remote proceedings. Ms. Thompson, would you please begin the announcements?
Jessica Thompson for the department.
Kira Lawrence, Belong Permanency Specialist. Belong Permanency Supervisor.
More Gianna's mother. And please announce if you can, Miss Flores Garza.
Crystal Garza, the mom.
Thank you.
Alana Pearsall, attorney for Carlos Navarro. Your Honor, this is a 262 as far as Mr. Navarro, as well as the status for everybody else. Mr. Navarro is present via Zoom. Ms. Navarro, will you please introduce yourself to the court?
Carlos Tapia.
Wait, I'm sorry. Could you say your name one more time for me, sir?
Carlos Navarro Tapia.
Maureen Llanes for the father, Jose Alfredo Vasquez Hernandez. He's a father, presumed father of Kimberly. I don't believe he has been served, and for that reason, not ready, Judge.
Donna Swallow, attorney ad litem for the children, Judge. I'm here on all hearings. I'm also ready on my motion to authorize placement of the children that was filed and set last Friday.
Greg Wilson for Alfredo Ayala. We are ready.
I need Mr. Ayala to announce, please.
Alfredo Ayala, Alexander, father.
Yes, ma'am.
Judy Houston, Supervisor, Hill Country Casa, Guardian Ad litem.
All right. Do you want to attempt to tell him while you're here in English with us to change it?
Can you hear me now?
Yes, we can still hear you in English. You need to make sure it says Spanish down there on the circle, and then try muting and unmuting original audio and see if that makes a difference.
Okay.
All right. Can you, I understand, Ms. Skinner. Can you just maybe do what we did last time and just get on the phone with him? Thank you. All right. Ms. Yanis is announced not ready. My understanding, Ms. Thompson, is that Mr. Vasquez Hernandez has not been served. Is that correct?
That's correct, Your Honor.
All right. I'm going to grant the not ready as to Ms. Yanis's client. Ms. Pearsall's client is here. Do you show a return of service on him, Mr. Novato Tapia?
You said what? I can't hear you.
All right. I'm not talking to you right now, Mr. Navarro. I'm just talking about you for purposes of the case. Ms. Thompson, do you show a return of service for him?
No, not for Mr. Navarro Tapia.
Ms. Pearsall, any objection to the court entering an appearance for your client today?
No, Your Honor. He wants to be here and to be involved and to do what he needs to do for his kiddos.
Okay, then I'll find that he's entered a general appearance today. And the department is relieved of the burden of serving him personally. And then Mr. Wilson, actually, Ms. Thompson, do you show that Mr. Ayala has been served?
No, Your Honor.
All right, Mr. Wilson, unless there's an objection, I'm gonna find that your client is entering a general appearance today as well.
That's, we don't have a problem with that, no objection.
Okay. All right, the department is relieved of the burden of serving Mr. Ayala as well. So as far as the 262 to Mr. Novato Tapia, the court has heard Ms. Pearsall's announcement that he agrees to the 262, agrees to the same findings that the court made at the adversary on January 8th as to the other parents, the mother and Mr. Ayala. And any objection to that? I wouldn't think so, but just to get everything on the record.
No objection.
Judge,
Yes.
I object to the weekly visitation.
Well, I'm not talking about so much the family plans of service and the visitation at this point as I am just making sure that we get it on the record that he is agreeing to the department taking temporary managing conservatorship.
Thank you. No objection.
Okay. All right. Ms. Garza, I need you to sit down and be still for me, please, ma'am.
It's because
All
I'm
right.
in the hospital with my mom. I'm sorry. I'm gonna come to the waiting room.
All right. So the court will find that it's in the best interest of the child for Belong and the department to be temporary managing conservators of the child of Mr. Ayala, or excuse me, Mr. Novato Tapia, and that the findings in the family code under chapter 262, so a full adversary hearing, be made. Miss Lawrence, it would not be Miss Lawrence. Who is the investigator on this case? I guess they're not here today, are they?
No, Judge.
All right. Well, if he's agreeing to it, I'm going to put it on the record that the same findings that were made regarding best interests and reasonable efforts in the prior hearing are made here as well. As far as Mr. Navarro Tapia, court will find that it's in the best interest of the child for the department to be named TMC and him to be temporary possessory conservator, that there's reasonable evidence to satisfy a person that abuse or neglect occurred due to an act or failure to act of the parent, and that reasonable efforts were made to allow the child to return home, but due to continuing danger, the child was not able to be returned home, and reasonable efforts were made to avoid a removal, but it was not possible. Court finds that the reasonable efforts were agreed to at the 262 as to the other parties, and that the affidavit includes a section stating which reasonable efforts were made, and makes that finding here today. We'll get to the visitation in just a moment. I need to address I think it might be a good idea to, and Miss Swallow, you tell me if you need to put on other evidence, but I want to go through the status hearing with Miss Lawrence and then talk about the situation with all the children. And then as we go through that, get your evidence for your ATP out at the same time? Or do you believe that we need to do it differently for your purposes?
No, Judge, that's fine. I attempted to confer last Friday. I haven't heard any objections, so I can't even give a proper time announcement.
Okay. Well, before we get into it, and I don't want to hear any argument, I just need to know, are there objections to the ATP?
Yes, Judge, there are.
Okay. All right. Ms. Thompson, this is a separate case, but it's a related question. Do we have service on the next hearing that's set at 10?
We do, Your Honor.
You do? Okay. All right, then we're going to have to be pretty expedient about this status hearing and the ATP. We'll get the evidence on, but we're not going to be able to take all morning with it because we already lost 23 minutes with the interpretation issues that we were having. So we're going to have to move pretty quick, but I'll make sure to give you enough time to get your evidence on. Just be efficient with it for me, please. Miss Lawrence, where are the children placed at this time?
They are placed in an emergency shelter.
The same one in Gonzales County?
Yes.
Is that placement safe and appropriate at this time?
Yes.
Are they up to date on all their checkups?
Yes.
Any concerns that we have right now with their mental, emotional, physical health that we need to address, or are all those things being addressed at this time?
They are being addressed. We are waiting for a developmental pediatrician to see the children.
Okay. Were you able to hold a family group conference as to Mr. Ayala and Miss Garza?
Yes.
At that family group conference, were you able to develop a family plan, a permanency goal, excuse me?
Yes.
What is the permanency goal at this time?
The goal right now is family reunification.
Is there any Indian child heritage in this case?
No.
Anything else that we need to address as far as the children are concerned today, except for the ATP, like any other needs that they have that you need relief from?
No, not at this time.
All right. Are any of the children receiving psychotropic medications?
Not at this time.
How are their behaviors?
So far, they haven't given me any incident reports. They appear to be adjusting well. Sometimes they're withdrawn and having issues with other youth as they're still adjusting. But placement seems to express that they're a delight.
Okay, good. And we've got three of them that are school age, are they all enrolled and attending?
Yes, they are.
Any issues there?
It's unknown at this time. They haven't said there's any issues, but they were placed right before break, and I think they've only had 1 week maybe, so it's still pending.
Okay. Are the children having visits with either Miss Garza or Mr. Ayala?
Yes.
Are those visits appropriate?
Yes.
Are you asking for any changes in the visitation schedule with Miss Garza and Mr. Ayala at this time?
I think we'll need to discuss that further.
You mean outside of court or here today?
Just due to the potential placement change.
Understood. Okay. Did you hold at your family group conference, did Mr. Ayala or Miss Garza participate in the creation of their plans?
Yes.
And are those family plans of service narrowly tailored to address the concerns that brought the children into care?
Yes.
Did they review and sign the plans?
Miss Garza signed in person with me, and I did review the plan and send it to Mr. Ayala. In Spanish as well.
Yes, I'm sorry. Yes, she is on 3 meters of oxygen.
Miss Garza, I need you to stay muted, please. So Miss Garza and Mr. Ayala both have a copy of their family plan of service, and his is in English and Spanish.
That's correct.
What sort of contact have you had with Mr. Garcia?
I have briefly spoken with Mr. Garcia. I haven't been able to meet with him for very long. I was planning on going yesterday, but due to the weather, I was not able to make it. But I did have our admin mail him the family plan of service. I'm scheduled to see him on, I think, later this week or early next week. I believe next week.
And then what about Mr. Navarro Tapia?
I met with him last week at the facility that he was incarcerated at, and expressed to him the services, and he is in agreement.
Did you make a plan for Mr. Navarro Tapia, Mr. Garcia?
I did.
All right. Do they have, I know you said the admin's going to mail him a plan. What about Mr. Navarro Tapia?
We will also be mailing him a plan.
These family plans are in the best interest of the children?
I do.
Are you asking for them to be named orders of the court?
Yes.
And are they all on file?
Yes.
Or we'll take judicial notice that they are filed. Did Miss Garcia, or Garza, excuse me, submit to the nail bed test as ordered?
She did not.
Do you have any reason as to why?
I lost all contact with her on January 8th up until yesterday afternoon, and she missed a hair, a UA, and a nail bed.
Did you explain to her that missing those drug tests is going to create issues for her?
I did.
Do you believe that she understands that her rights could be subject to further restriction if there are safety concerns due to her using?
Yes.
Does she understand, to your knowledge, or do you explain to her that missing drug tests creates safety concerns?
Yes.
Okay. Did the children have their hair strand tests?
They drove to the facility, and the facility stated they do not do hair strand tests, even though we're contracted with them. So I'll need to reschedule that pending the placement move.
The forensic interview was to be translated from Spanish to English. Do you know if that process has begun?
It has begun.
Do you have any kind of timeline on that?
Not at this time.
Did the children get their haircuts and their undergarments?
We are waiting for the haircuts until after the hair test.
Okay, that makes sense. What about the clothes, the undergarments and things?
I have not purchased them myself. I'm not sure if placement has, but that's something that we were going to discuss with the new placement as well.
Did the grandparents participate in any visits?
I'm sorry, can you repeat that?
Have the grandparents participated in any visits?
No.
Have they had any phone contact?
Phone contact was being set up with Miss Garza's mother. It's just, I'm not aware at this time due to the placement change, if it took place this week or if they were waiting to start that next week.
Okay. At this time, is it safe to return the children to any parent?
Not at this time.
Are there still concerns that exist?
Yes.
Okay. And is it in the best interest of the children to remain in the temporary managing conservatorship of the department / belong?
Yes, it is.
You testified that the current placement is safe and appropriate, meeting their needs. There is an ATP on file today. What is Belong's position on moving the children at this time?
Belong is in agreement. It's very rare to find a bilingual foster home that will accept all 4 children, and they've been doing this since 2015. So we're very, very pleased about this placement.
What county is it in?
El Paso.
Have the children had an opportunity to discuss this placement, or do they know about it yet?
Yes, I spoke with them myself yesterday, and I believe their attorney also spoke with them previously.
Okay. So you believe they've had an opportunity to express their concerns and desires?
Yes.
How do they feel about things?
They're the 2 girls that I spoke with over the phone. I did not speak with Bentley or Andre. They were speaking at the same time, so I wasn't sure who said what, but one of them expressed that they do not want to leave the placement they are at because they enjoy it, but they also expressed that they want to go on a plane, and the home that they're going to will have less children, which they're excited about as well.
So do you believe it would be in their best interest to leave the shelter and go to this placement?
Yes.
How would the visitation be facilitated if the children were moved to this placement with the parents?
I believe we could continue the 4 hours a month that they receive. It would just be either all at once or twice. There would be some makeup time still because they are scheduled to have a visit tomorrow, which I don't believe would be able to take place. I have those hours written down, and I am in communication with the parents about what their makeup time looks like. We are also not currently contracted with a visitation agency out there, but there is a contract in the works as of yesterday afternoon.
Okay. What do you think would be an appropriate visitation location for that 4 hours a month?
I don't know, Your Honor. The placement has a lot of ideas. They have done lots of visitations in the community. And the visitation agency also expressed that they do visitation in the community. So I would just rely on their recommendations.
When you say the community, do you mean their community the kids are from, or the community that the foster home is in?
The community the foster home is in El Paso.
What concerns, if any, do you have about moving the children from the shelter to this placement?
The main concern is visitation. It is an extremely tough barrier to work through, 7, 8, 9 hour drive. I am open to discussing with the parties what visitation could look like, whether that's day visits or whatnot, just because going through all of that travel time would be difficult. But I am not in agreement to bring the children down to the parents. So it's just something we're gonna all have to figure out. That's my main barrier. That's my main concern. The children love their visits. That was the first thing they brought up yesterday when we spoke.
So the main concern is the visitation. Looking at the placements themselves, we've got 4 children, young children, and they're in an emergency shelter, which I know we covered at the last hearing. It's kind of a misnomer for this place because they're actually doing very well there. How far is that shelter away from the parents at this point in time? How many hours?
It's about 2.
Okay. And then we'd be switching from 2 hours to about 6 to 8, depending on which way you go, right?
That's correct.
Okay. Do you believe that the needs of the children and the care that they would receive in the foster home would be an improvement on the care that they're receiving in the shelter?
Absolutely. I think that one-on-one time is going to be extremely beneficial.
All right. And you mentioned that the foster home is bilingual. Are there bilingual Spanish speakers in the shelter?
Yes.
Okay. Do the foster parents have any other children in their home?
I believe they have one child that may be their own or that may be going through an adoption process. It was unclear. It happened quickly.
Do you believe, based on what you know, that there would be any strain or stretching of resources for this family to take in 4 children?
No.
And you say they've been licensed since 2015?
Yes, they specialize in sibling groups. That's the reason they opened their home.
Okay. At this point in time, have Mr. Ayala or Ms. Garza engaged in any services? I know you already testified to the drug test, but have they started anything else?
Mr. Ayala has engaged. He completed an intake with a therapist, a psychosocial assessment. He got set up with his parenting program. He has made every drug test that I've sent him to. He is tested clean. Miss Garza, since I have not heard from her, I'm unaware if she has engaged in her parenting program. I did send her for an OSAR, which she missed, and I rescheduled that. And I texted her that new date as well.
At this point in time, does Mr. Ayala have suitable housing for the children?
Yes.
So he could take in all the children if he had to?
There are concerns since his child was removed from him.
Well, I'm not talking about the concerns. I'm just talking about, does he have suitable housing?
For his child, yes. I don't believe he could accommodate all 4 children.
Okay. So even if he were to, he has the ability to care for his child in his home, but not the sibling group, but he still has too many concerns to address before his child could even be returned to him, correct?
That's correct.
All right. And then as far as the mother, your testimony suggests that you're unaware of what she's done. She's missed 3 drug tests. And does she have suitable housing? Again, notwithstanding concerns that exist, is her housing suitable for 4 children at this time?
Her housing is unknown. A local worker went out to her last residence and they stated she's no longer living there. Judge, I did forget to mention that she did submit to an oral swab for me when I met her the first week of January, and it was positive for methamphetamine.
Okay. All right. Ms. Thompson, do you have any questions for Ms. Lawrence regarding either the status hearing or evidence related to the ATP?
No questions, Your Honor.
Ms. Mance?
Yes. How long can the children actually stay at current placement?
I'm not sure. I think it's different for every case.
Well, isn't it true that even if they gave notice, because it's an emergency shelter, that an extension can be granted?
I am unaware.
You're unaware as to this case, or you're unaware that this is routinely done at this placement in Gonzales?
This is the first time I've had children placed there. I'm unaware of their policy, but Belong's policy is we don't have substantial reasoning to deny a placement that's available when children are placed in a shelter.
What is the current visitation schedule?
Right now, the parents are getting 4 hours a month, and Mr. Ayala is taking those weekly. He's driving up there, and then Miss Garza is going every other week.
And so she will see her children tomorrow. That is the current plan.
That is the current plan.
And what is the status of any home studies on relatives?
I submitted a preliminary home study on one relative from one of the older children, one of the girls, yesterday. It has not been gone through. It hasn't been completed, but I submitted the preliminary.
So there's potential for local placement with family, correct?
There is potential.
And wouldn't that be in the children's best interest to wait and see if that home study is appropriate?
That home is only willing to take one child. And that's kind of the problem I've been running into with the separate fathers. Each family has shown interest in one child, so I think it's imperative that the children want to stay together, and this bilingual foster home would like to keep them together.
But the children also want to have frequent access with their parents, correct?
That's correct.
And at this time, if placed in El Paso, you have absolutely zero plan right now for visitation, correct?
I would disagree on the zero plan, but I understand your concerns, and the plan is not concrete.
So it's not specific as to times and dates for parents.
That's correct.
So it's fair to say that you have no plan that gives specific times and dates for visits between parents and children.
For specific times and dates, I agree, but I disagree with the no plan. We would continue the 4 hours a month at everybody's availability.
And when you say everyone's availability, how do you think that these two parents are going to get to the El Paso region?
I would need to discuss that with them and what their travel plans are.
So if they have no ability, then they actually have no ability to exercise visitation, correct?
My supervisor informed me that we are willing to.
I'm not asking you what your supervisor said. I'm not, please don't respond as to hearsay statements, but currently you're aware that mother has no ability to travel to El Paso.
I was trying to inform you that we can provide bus passes. I have been given approval to provide bus passes for the parents.
To El Paso?
That's correct.
And how many days would it take her to get from San Antonio, Kerrville to El Paso?
I have not looked into that.
So you're not aware that it could take 2 or even 3 days one way to get to El Paso?
I'm not aware of that.
How many schools have the children attended this year? This school year, let me correct that.
At least 2.
So if they were to be moved, then they would be on their 3rd.
That's correct.
Minimum, could actually be more.
Correct.
And when you explained to the children that they might get to go on a plane, did you also explain that they may not have the ability to see their mother anymore?
They were concerned about the visitation.
Okay, my question was, did you explain to these children that yes, you're going to get to go on a plane, it's going to be great fun, but you may not see your mother for months? Did you explain that?
Judge, argumentative.
Judge, I'm asking a very specific and very relevant question. She made a comment that they were all excited about the plane ride, but that may be true because they've probably never gotten on a plane. But did she also, in that same conversation, explain, but on the downside, you're probably not going to get to see your mom for months?
I understand what your intention is. It came off a little argumentative. Just rephrase. Miss Lawrence, you hear the question?
Yes,
All right. Can you answer it that way, or do you need her to ask it again?
I can answer it. I did explain to them the barriers of visitation when they said they were concerned. I ensured them that we would follow the court orders currently that are 4 hours a month unless the orders change.
So what were the barriers that you told these 2 children or 4 children about?
I told them it was very, very far.
And did you say that, in fact, your mother may not be able to go because she doesn't have transportation and a bus would take 2 or 3 days one way?
Judge, argumentative. I mean, Miss Mance is stating things that aren't even true.
Yes, it's absolutely true. That's absolutely true. I know that's not what Miss Swallow wants to hear, but that's true.
Well, I think what we're getting into, I understand the concern as far as the travel distance. You know, unless there's somebody here from a bus line testifying to exactly how long it takes, then anything any of us say about the travel time is speculative. So, but I understand it's not going to be a day trip. I understand that. Geographically, no one, unless they can teleport themselves, is going to make it to El Paso and back in one day. It's going to take at least 2 days. So we can move on from that.
So why would a visit not happen tomorrow for mother?
I would believe that a visitation may not happen due to placement happening today, and planning a drive out there.
Why would you not postpone placement until after mother's visit, given that she may not have a visit for a couple of months even?
Because they are in an emergency shelter and a placement has been identified, if it is approved, we would place the children as soon as possible.
But you could actually place later this week, correct? It doesn't have to be tomorrow.
I don't believe so due to the availability of the placing agency. We've already discussed quite a few days and they have told me that they're not available.
So they're only available tomorrow?
They are available today and the plane tickets have been purchased.
So without a court order, you went ahead and purchased at the state's expense plane tickets for 4, if not 5 people.
We have a contract with the airline and we can cancel them, but it was my responsibility to purchase to ensure that today we could move the children if we got agreement.
So since you have that contract, you could actually cancel those tickets and either the children remain where they are or the children go at a later date.
We could. I don't believe it would be beneficial. The children were packing yesterday. The placement got them suitcases, and they were informed and they've been getting ready, charging their electronics. We have the placement ready. The placement agency is planning to meet us there at the home.
So prior to court order, you've already told these children to start packing.
That's correct.
Objection, Your Honor. At this point, I'm going to argue as the relevance and it's duplicative. We're beating a dead horse to death. I understand what she's getting at.
Well, what I'm trying to do actually is what my clients asked me to do, which is oppose a move of her 4 children. So just trying to do my job, Mr. Brandon.
No, I understand. It's just we're kind of beating a dead horse to death. Is why I'm objecting.
I think with the time that we have and how long it took us to get going and the time that this examination has taken, I feel I strongly understand your client's position, Ms. Mance, and I understand the concerns with the placement, the geographic problems that it creates, and then also the timeline as to if the placement was ordered, what would be best to allow mom some visitation. I've got it all. Unless there's something else that I haven't heard yet that you need to cover, we're going to need to move on just because I've still got another case on the docket this morning.
Well, and Judge, I'm going to have to call my client as a witness. She wants to impress.
That's fine. That's fine. But I don't, I'm talking about Miss Lawrence. Do you have anything?
I have
Miss
two more
Lawrence?
questions. I have a
Okay.
list that I made during her testimony. I have two more questions.
Okay.
Ms. Lawrence, you stated that current placement is 2 hours. Actually, isn't it correct that it's 1 hour from San Antonio?
I'm not sure from San Antonio. That's not where the parents reside.
Well, the mother's currently in San Antonio, correct?
I don't know her whereabouts.
And you understand that mother has had some very significant issues with her mother in the past 2 weeks.
No, she did not make me aware. She would not respond.
You're not aware that she's been at the hospital with her mother for a significant period of time?
No, I was not aware.
All right, thank you. I'll pass. Well, isn't it true that your supervisor actually informed me of the reason why she was at the hospital? So did your supervisor not inform you?
I was informed about 20 hours ago.
So you do know that she's been at the hospital with her mom?
Yes, but not within the last 2 weeks, just within the last about 20 hours.
I'll pass the witness.
Mr. Brandon?
I got nothing, Judge. Just to recap, because I was kind of late to this. I logged into the wrong county. That was my bad. I was wondering why you weren't letting me in for a while there. And then Shara texted me. So I'm glad to be here. My client is still incarcerated. I believe the last time we were here, I just requested a DNA test, and I have no questions for this witness.
Okay. Just before we move on, Miss Lawrence, do you know if that DNA test has been initiated?
It has been sent through, but it has not been conducted.
Want to make sure it was started. All right, then, Ms. Pearsall, any questions?
Yes, Your Honor. Thank you. Ms. Lawrence, does the parents have 4 hours visits a month, correct?
Correct.
And you agree it would be fair for Mr. Navarro Tapia to have the same thing?
Yes.
No other questions.
Mr. Wilson?
Thank you, Your Honor. Ms. Lawrence, you testified earlier that Mr. Ayala's home is appropriate to at least take his child. Is that correct?
That's correct.
And have you had a chance to speak to his mother about being a possible placement in his home?
I have not spoken to his mother.
Were you aware that he was making arrangements to have her move to his home with the hope of her being the placement?
Yes, I was aware.
Okay. And Mr. Ayala has complied with what you've asked him to do. Is that correct?
Yes.
Now it's the policy to keep sibling groups together. Given Andre's age, do you believe it's possible and maybe even appropriate that he be placed with a relative close to where his father, who is compliant, will be able to visit him without having to drive 6 hours?
I don't know if I have the availability to speak on whether or not it's appropriate for his developmental age.
Okay, he's only 2 years old, correct?
That's correct.
So in these conversations that you're having with him, has he been really able to participate, or is he just kind of sitting there babbling?
He has not been able to participate.
Have you been able to observe the interaction between Mr. Ayala and Andre?
Yes, I have.
Does Andre enjoy his interaction with his father?
Absolutely.
And so in a sense, this would actually be punitive to Mr. Ayala to have him to drive 7 to 8 hours to visit, in that he is actually the only parent at this point in time who appears to be complying with what the department is asking him to do.
Yes.
Pass the witness, right?
Ms. Swallow?
Thank you. Miss Lawrence, is this case about the parents' best interest or the children's best interest?
The children's.
And Has any placement come about that would allow the children to continue to be placed together besides the one that's been identified in El Paso?
No,
And this includes the placement search that Belong is doing, as well as any names that the parents have provided.
that's correct.
And last you knew, where was Mother living?
In Houston,
And where were the children living when they were removed?
in Comfort.
So Mom, even prior to the children being removed, wasn't even living in the same town where her kids were residing.
That's correct.
As far as Mr. Navarro Tapia, do you know how long he's incarcerated?
I don't know.
Okay. So you have no idea whether or not he'll be released anytime soon.
When I met with him, he told me he was hoping his bond would decrease and then he would be able to get out soon, but I don't have a timeline.
Okay. And do you know the last time he saw Amber?
I don't recall.
Okay. Do you believe that if the court were to grant my motion to move the children, that it would be prudent for the children to be able to have access to virtual communication with Mr. Ayala and Miss Garza?
Yes.
The frequency of that, would you say would be weekly?
Yes.
As far as the 4 hours a month, is Belong opposed to increasing that time to maybe 5 or 6 hours a month so that the travel would seem worth it?
Belong is not opposed.
So for example, they could have 2 3-hour visits a month.
That would, yes, I agree.
And then with compliance, that could be increased.
Yes,
And with the goal of reunification, hopefully that wouldn't take too long.
I agree.
I think that's all I have, Judge. I pass the witness.
Ms. Giannis, I skipped you because you announced not ready. Do you have any questions for Ms. Lawrence based on your client or regarding the client?
No, Judge, thank you.
Okay. All right. Miss Swallow, or actually Miss Thompson, do you have any other questions or any other witnesses?
No, Your Honor.
Okay. Miss Swallow, we're here on your motion outside of the status hearing. Do you have any other witnesses for your motion?
No, Judge.
All right. Miss Mance said you wanted to call your client, correct?
Yes, Judge, she wants to testify.
Okay, you may do so.
Miss Garza, can you state your full name for the court?
Crystal Alejandra Flores Garza.
And why have you not been cooperative with the department in the past 2 weeks?
Because I got my phone service disconnected and I just been in the hospital with my mom. I'm still in the hospital. She's right now in the hospital. She's been really sick, and that's why I haven't been able to go and do all these drug tests and stuff.
And did you inform Miss Crouch of that?
I know because I didn't have phone service and I was just too worried about my mom. I left my phone in my purse, but as soon as I got phone service, I was calling her to let her know.
And when is your OSAR scheduled for?
She said she sent me a message with the new date, but she didn't.
But you're going to make that appointment?
Yes.
You're going to cooperate with the hair, nail, and
Yes.
UA?
Yes.
And where are you asking that your children be placed?
Well, right now I want them to stay where they at right now, because when I talked to my kids on my first visit, they were kind of upset and wanted to go home with me, but they said I told them that I had to finish school, and when I finished school, they were gonna be able to come home. But my oldest daughter, she said that she doesn't want to move anywhere else. But I mean, I'm trying my best to do what they're asking, but with all this, my mom being in the hospital, it's just been really hard.
All right, thank you. I'll pass, Judge.
Ms. Thompson, do you have any questions?
No, Your Honor, no questions.
All right, go ahead, Ms. Swallow. If anybody else has any questions, I'll let them go after you since it's your motion.
Thank you, Judge. No questions for Ms. Garza, just to address the court, Judge.
Does anyone else have a question for Ms. Garza while she's on cross?
Yes, Your Honor.
All right, let me let Mr. Wilson ask a few questions before I hear any argument.
Ms. Garza, I have one question for you, one question only. Given the choice between Mr. Ayala's mother and being placed in El Paso, which one would you rather have your Andre placed with?
With Alfredo's mom.
No further questions, Your Honor.
Okay, if we're ready to give argument, anybody else have any other questions or witnesses or any other evidence I need to hear?
No, Your Honor.
All right, let me go in order. Let me start with Ms. Thompson. Ms. Thompson, what's the department requesting today as far as, I know what your position is. Are you requesting anything else, or do you want to make any other statements?
No, Your Honor, just that the department is in full agreement of the ATP and for the potential or prospective new placement for the children.
Thank you. Mr. Brannon, or sorry, Ms. Mance.
Judge, I think Ms. Swallow had a really good question for the department. Is this in the children's best interest? This whole case, whose best interest are priority, children or parents? Well, what I'm hearing is, yes, it's the children, but on the other hand, the department, without even having had this hearing, has already told 4 little kids to get their bags packed, hasn't even actually told the kids, oh, and by the way, you're going to miss a visit with your mother tomorrow, and you may not see your mother for a couple of months. So what I'm hearing is this move with a home study pending and with no notice, the shelter, they can stay there 90 days, if not longer. With no notice, the department's in this big rush to move these kids about 900 miles from where they are. They'll be on their 3rd or 4th school. They won't have probably any decent contact with parents. I think anyone knows that a bus to El Paso is a 2-day one-way trip. So it is just not realistic that when you announce a permanency goal of reunification, that you're going to move 4 kids way out across the state where they're not going to visit with their parents, not even the one parent that's fully compliant. And yes, mom is not fully compliant. She's been at the hospital. The department's aware of it, as I was made aware of it yesterday. She's got that OSAR that she's going to get rescheduled. She's going to get on board. We are basically about 2 weeks after we concluded that second day of the 262, which was January 8th. So she's slow to get started if you think that it's the 60-day. But on the other hand, the 262 was granted less than 2 weeks ago. So I'm asking that the court not move these children, that other options be fully explored, and they're in a great placement. They like it there. But the main thing is they want a relationship and access to their parents. Thank you, Judge.
Mr. Brannon.
I got nothing, Judge.
Ms. Pearsall.
Your Honor, I just want to ensure that Mr. Navarro Tapia gets the same rights, sold out appearance, and he gets his visits weekly. And if the court elongates those visits, that his are elongated as well to 6 hours or whatever it is that the court is willing to order. He came forward despite not being named in this lawsuit correctly. Clark County Jail, I'll actually give them pointers to. They actually followed an in-person bench warrant, which honestly shocked me. And then when at the last minute to switch it to Zoom, they cooperated and got on Zoom. And I think it's the first cooperative jail I've dealt with in the last 6 months. So I won't tell them. I appreciate that they actually followed a court order. But he's willing. He hopes to be released very soon, and he really wants to work services. And I just want him to be treated fairly and his constitutional rights to be protected as far as implementation. And that's all.
Thank you, Ms. Pearsall. Mr. Wilson.
Your Honor, notwithstanding the department's policy on keeping sibling groups together, which I understand is important. We have a 2-year-old child who is not able to communicate as effectively as a sibling simply because of his age. However, that 2-year-old child's father is doing what he needs to do to comply with what the department wants. And it creates an issue for the court. Your Honor, what I would propose here is that this ruling be held in abeyance or stayed until such time as we can have an expedited home study on Mr. Ayala's mother, given that the housing is appropriate and that she has been willing to do that. And then, if it needs to be staffed with the department as far as separating Andre from the other 3 children, so that Mr. Ayala, who has been compliant, is able to visit without having to either take a bus for a day and a half or drive 6 to 8 hours to El Paso, would be how I would handle that, Your Honor, because at this point, notwithstanding the fact that this is in the best interest of the children, we have one parent who is doing what he can, what he needs to do to be able to have access to his son. And this move, goes against that.
Thank you, Mr. Wilson. Ms. Yanis, did you have anything?
I take no position, Judge.
Ms. Swall?
Thank you, Judge. The children are aware that they're at a shelter and it's not a permanent placement. The children deserve to be in an environment where they can remain together and where they have that one-on-one nurturing family type setting. I think that they will thrive in that environment. I was able to do a virtual visit with this potential placement as well as review their home study. I asked a lot of questions. I was very inquisitive, and I believe that this family is committed to these children and they're ready and able to meet their needs. I want to make sure that if the court is inclined to grant my motion, that the children be allowed to go today. I do not want to do anything that may risk this placement. It's rare that we have a placement that can take 4 children. I'm advocating that Mr. Ayala and Ms. Garza's visits be up to 6 hours a month. So it would be 3 and 3 or just one full stretch of, I think 6 hours is a lot, but I think the 3 and 3 or however the court thinks that should be done. I also think they should have weekly virtual visits with their parents as well. This information that it takes 2 days or a day and a half, Greyhound takes about 9 hours to get to El Paso. So I think we need to do a little more research in that area, but I think we're inflating the travel time a little bit here. As far as Mr. Navarro's visits, I would request that we assess that upon his release from incarceration and his engagement in services. And this third-party agency that Ms. Lawrence testified to, if the court does grant the motion to move the children, I would request that Belong be ordered to pay for that third-party agency if we're unable to secure a supervisor for the visits, I guess in the interim until the contract is secured. That's all I have at this time, Judge. Oh, one other thing. We keep talking about Mr. Ayala's mom. It's my understanding she doesn't even live here. I could be wrong, but I don't think I am. So if she doesn't live here, it's hard to study her. And so I think that's still another issue that remains as far as placing Andre with her. These kids can all stay together in this placement and potentially have even more time with their parents than they're currently having.
Do you know where Mr. Ayala's mother lives?
I believe she lives in Mexico.
Say it again, Ms. Solid.
I believe she lives in Mexico.
Mr. Wilson, is that correct?
She is a resident of Mexico, Your Honor. However, she is moving here. Mr. Ayala is in the process of adding her to the lease at his apartment right now.
Ms. Lawrence, do you have any information on an actual realistic time frame for that study if she is a resident of Mexico but is moving here?
My understanding, according to what has been told to me by Mr. Ayala, is that she arrived on Friday of last week, and that due to the holidays, Martin Luther King and the weekend, the office was closed, and that yesterday they were going to go and attempt to add her to the lease. In order for us to do a home study, he would also need to be off the lease, and home studies could take a month, if not more.
Which is why I requested that it be expedited.
Ms. Latrell?
Yes, Your Honor. CASA is in agreement with the move. I was able to sit in on Ms. Swallow's interview with the family. They are very appropriate. An emergency shelter for the 4 kids, and the little guys need some one-on-one attention, especially. So we are in favor of the move.
Issues, CASA, in your report, you had recommended some different therapies and things like that, and evaluations. Do you believe that if the children were moved to El Paso, that those services and those needs would be met in that new placement as well?
Yes, sir. This family is very experienced, and they have the resources at their fingertips.
Do you believe that these services and these evaluations and assessments are going to be, I don't want to say more easily acquired, but do you think that this foster family has a better bead than the shelter on getting these things addressed and a better ability, or do you think that that is the same between the two placements?
I believe they will have more time to be able to schedule these things, and it's a large market, of course.
Okay. Ms. Thompson, you're the petitioner. Get the last bite at the apple here before anything else. Is there anything that the department has that I have not heard yet, or anything else that you want to rebut?
Nothing further, Your Honor.
Okay. There's quite a bit of information here. We have a lot of parties, and this is a monumental decision in the lives of these children. This is not a 1 or 2 hour move. This is a complete and total lifestyle change. And I need to absorb some more of this and go through the reports again and go through my notes from the hearing before I make a ruling of that magnitude. So I'm going to take it under advisement, and I'll have an order out by the end of the day. Thank you for your time and your service. All parties are excused.
Thank you, Judge.
Thank you.
Thank you.
Thank you.
Speaking at the moment, if you could please keep yourself muted. Our 10 a.m. or 9:30, excuse me, obviously ran very late. So there's been adjustments having to be made on everybody's part. Understand that. My understanding is that everybody's been served in this case, and that it's the intention to proceed. I don't know if you've all had the opportunity to confer. Have the attorneys conferred?
No, Your Honor, and I have not had contact with my client, Guadalupe Sandoval. I also have another adversary hearing beginning in 1 minute in Judge DeGirolami's court.
And I'm on that hearing as well. I did let the court coordinator know that I was still here.
All right, so for the two of you, let's look at it this way. Miss Acosta, your client hasn't been served, correct?
That's my understanding, correct?
So, and your client is the father?
Yes.
But we've got service on Miss Ortiz and Mr. Rudkin's here. So, without service on Mr. Sandoval, I would be inclined to grant a not ready and excuse you at this time because we can't accomplish anything anyways. So, that would handle that for you, and you are excused.
Thank you,
Your Honor. You're welcome. For Miss Mance, you've got the children. I think if at this point in time, Miss Thompson, have you conferred with Mr. Rudkin or Miss Mance?
I have not had the chance to confer with them, Your Honor, no.
Okay. What if I put you in a breakout room, Miss Mance, and you just took the first few minutes to let Mr. Rudkin and Miss Thompson know what your feelings were?
Yes, Your Honor, that's great.
Okay, let's do that. And then once you've done that, you're excused to go to Judge D's court, and then we'll figure out where we're going to go from there. You can just let her know that I am waiting on you to come back.
All right, Judge.
All right,
I
I'm
think
putting
it should
y'all.
be fairly fast, I hope.
Okay, I'm putting you, Miss Thompson, and Mr. Rudkin in a breakout room with Casa. Who do we have here from Casa? Just Miss Houston? All right.
Yes, Your Honor, I'm here.
Okay, that room is open. We'll be in a recess until they've had a chance to talk.
¿Qué onda? ¿Qué es lo que está pasando?
All right, we're in court. I need you to remember that we're in a courtroom. There can be no private conversations between people in the courtroom.
I'm trying to see what is sound. I have no sound for anybody.
You have sound, sir. We can hear you. We're just waiting for the attorneys to come back in. So if you just keep yourself on mute, we'll get started here in a few minutes.
Okay, thank you.
You're welcome.
Looking at who's all at the conference. There's a bunch of people in the conference. Because I would like to see who's attentive to my kids' hearing. Just the people that are like the. So there's two other people who are here. Hmm?
Miss Thompson, you have, it looks like a few witnesses here. And because we have an agreement with the mother, at least, do these witnesses need to stay?
No, Your Honor, they do not need to stay.
Okay. Will that be Mr. Daggett or Officer Daggett and Mr. Barbo?
That's correct, Your Honor.
All right, gentlemen, we have an agreement with the mother, and then I'll discuss the issue with the father, but we appreciate your patience in being here today. We've had a docket that's run a little bit late, so I thank you for your time and I apologize for the delays. Your services are no longer necessary today, but thank you, and you both are excused.
Thank you, Judge.
You're welcome. All right, court calls cause number 2 in the 198th Judicial District Court of Kirk County, Texas. Court is broadcasting via Zoom and YouTube due to some inclement weather concerns this morning. Ms. Thompson, would you please begin the announcements?
Jessica Thompson for the department, ready.
Ashley Peterman, Child Protective Investigations.
Kurt Rudkin, attorney for the mother, Yvette Ortiz. And she's present. Can you announce, Yvette? Uh-oh.
Ms. Ortiz, are you able to announce? I think your microphone might be off. Well, this is the morning for it.
Yeah.
Mine is messing up. Okay, I'm sorry. I'm having trouble with my microphone.
That's fine. You just state your name for me?
Yes, sir. My name is Yvette Ortiz, the mother of the children.
Okay, you're good. I can hear you. I can see you. You're good. All right, no worries. Okay, let's continue with announcements. Mr. Sandoval, could you announce for me, please?
Yes, sir.
I need you to state your name if you would.
I'm Guadalupe Sandoval, the father of the children.
Thank you. Ms. Houston?
Judy Houston, Hill Country Casa, Guardian Ad Litem Supervisor.
Anybody that hasn't announced? Okay. If you're not an attorney or you'll be giving testimony, please raise your right hand. So, Ms. Ortiz and Mr. Sandoval, your right hands, please. Do each of you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yes, I do.
Thank you.
Yes, Your
We're here
Honor.
today for an adversary hearing. It's my understanding. Who is Evan? Is that the audio that's with you, Miss Ortiz?
Yes, sir.
If so, that's fine. I just need to make sure I know who everybody is. Okay, thank you. We're here for an adversary hearing, and my understanding is that Mr. Rudkin and his client, Ms. Ortiz, have entered into an agreement with the department, and that Ms. Mance, the ad litem for the children, and Ms. Houston, who's here for CASA, are in agreement with that as well. Ms. Mance and Ms. Acosta, who is Mr. Sandoval's attorney, are currently in another adversary hearing in another county because this docket this morning ran late due to our first hearing taking a while. So where that puts you, Mr. Sandoval, is your attorney is not present right now, and I'm not going to force you to enter into any agreement or to go through this hearing without benefit of your appointed counsel. So I'm giving you the option. We're going to go ahead and enter the agreement that the department has with Ms. Ortiz on the record today. If you want to be a part of that agreement without talking to your attorney, it's your case. You have the opportunity to do that. But if you have any doubt at all that you want to enter into that agreement and you want to talk to your attorney first, I'm giving you the option to do that as well. So you can say, Your Honor, I don't want to do anything today, and I'll reset you after you've had the chance to talk to your attorney. Does that make sense?
Yes, sir.
Okay. I don't want to lose the time that we have here with Mom and push the whole thing back. If I get agreement with her and I can enter that, then we've accomplished something this morning. So what's going to happen is the agreement that they're going to enter into is going to involve the department represented by Ms. Thompson and Ms. Peterman here. They're going to take what's called temporary managing conservatorship of the child or the children, excuse me. And that's going to allow her to work some services and work towards getting the children back in the home after she's done some work. If you enter into the agreement, then you would be subject to the same thing, which would become an order of the court. So if you would rather talk to your attorney before you do any of this, I need you to tell me that now. Otherwise, I'm going to move forward and I'm going to assume that you're waiving the opportunity to talk to your attorney and enter into this agreement with you present. You don't have to do that, and that's completely your decision.
Okay.
So would you like to talk to your attorney before you enter into any agreements or before the court does anything else?
So the agreement would be what again? I'm sorry.
Let me stop you there. I don't want to speak out of turn. I don't know exactly what the agreement is. I just know that it's going to wind up being where the department takes temporary possessory conservatorship. Ms. Thompson, could you state the agreement on the record for me, please?
Yes, Your Honor. For the department to be designated as a temporary managing conservator, for the parent or parents to engage in services recommended by the department belong, specifically random drug testing such as UA, hair follicle tests, nail tests, parenting class, individual counseling. And psychological assessment evaluation.
All right, so where would the children be placed as part of this agreement, Ms. Peterman?
Your Honor, we do currently have some options that Mother provided that we are exploring, but as of right now, I can't speak as to what's going to happen after today. I believe Belong would be exploring those options.
Well, I guess what I'm asking right now is, without telling me exactly where they are, what type of placement are they in right now?
Oh, I apologize. They are currently in a shelter.
In what county?
Bear County.
They're in a
Okay. All right, so that's the agreement, Mr. Sandoval, and the children will be placed in that shelter until another placement is found for them, while Miss Ortiz works these services that the department wants her to work. If you agreed to it, you'd be doing the same thing. And I just need to know if you want to agree to it or if you want to talk to your attorney first. And that's your decision. I cannot make it for you.
And if I don't agree to this right now, I would have to be put in into a reset.
Yes, we would reset the case, and I'd give you and your attorney the opportunity to hold a contested adversary hearing where she could put on evidence for you, and you two could basically fight the case and try to come up with an alternative resolution.
And meanwhile, the kids would stay with the in the shelter, correct?
Correct. Correct. It seems to me as if you're having a hard time with this, and that gives me pause. I'd rather you talk to your attorney first.
What if he does not choose to take it now for the reset? That way he does speak to the attorney, but what if later on he does agree to the agreement after he speaks to the attorney? Is he able to do that?
He can always agree to it later. He can always agree to it later.
So I feel like that's where his concern may be.
Yeah. All right. You can always enter into this agreement later, Mr. Sandoval, but it looks to me, just from the look on your face, that you're kind of concerned about doing it today.
Not at all. I mean, I just wanted to make sure that my options are I'm just considering everything. It's kind of tough. This is one of the first times I'm actually hearing about this. I mean,
okay. Then I'm going to go ahead and make the decision that I want you to talk to your attorney first.
okay.
So I'm going to, Miss Greenlee, if you could get me a reset date for Mr. Sandoval, and I think a status hearing would probably be fine. If he wants to agree to it in between now and then, we could certainly circulate an order. But I think we could probably do that on the status hearing.
However, if he does want to contest it, they'll need to let me know so I can find another date for that.
Right, and just let Miss Acosta know after she talks to him to inform you. Okay, so Miss Ortiz, you heard the agreement that Miss Thompson stated on the record?
Yes, sir.
That's the agreement you made?
Yes, sir.
You entered into that agreement voluntarily? What I mean by that is nobody forced you to agree to it, did they?
No, absolutely.
Nobody made any promises or inducements or anything like that to get you to agree to it, did they?
No, absolutely not. Just
right.
me and my lawyer.
Okay, thank you. All right, Mr. Rudkin, that's your understanding of the agreement as well?
Sorry about that. Yeah, it is.
Okay. And then the parties were able to speak with the attorney ad litem, Ms. Mance. Ms. Thompson and Mr. Rudkin have represented to me that she was in agreement with the department taking temporary managing conservatorship. So I'm putting that on the record now, that's the understanding the court has. And then Ms. Houston, does CASA agree to that?
Yes, Your Honor, we do.
Okay. Then, Ms. Peterman, do you believe that all reasonable efforts were made in this case?
Yes, sir.
You believe that this agreement's in the best interest of the children?
Yes, sir.
Do you believe that abuse or neglect occurred and that there was a danger to the children caused by an act or failure to act of one or more of the parents?
Yes, sir.
And do you believe that efforts were made to allow the children to remain home, but due to a continuing danger, the children were not able to remain home?
Yes, sir.
And do you believe that efforts were made to prevent a removal, but due to
Yes,
the
sir.
facts and circumstances, the removal was necessary?
Yes, sir.
All right. Court will take judicial notice of the affidavit, and based on the testimony of the caseworker and the agreement of the parties, the court will make those findings as stated in the code and name the Department of Family Protective Services as the temporary managing conservator of the children and name the mother, Miss Yvette Ortiz, as the temporary possessory conservator. Court's going to order the parties to hold a family group conference to develop family plans of service that are narrowly tailored to address the concerns that brought the children into care. And my understanding is that the parties have discussed random drug testing, including urine analysis, hair follicle tests, parenting classes, individual counseling, and psychological assessments and evaluations. Obviously, if you come up with some things at your family group conference that you believe would be helpful, you can add or subtract those things, and we'll talk about that at the status hearing. Court finds that the current placement of the children is a shelter in Bexar County. The court will maintain that placement, find that it's safe and appropriate, meeting the needs of the children. And we'll be back for our status hearing March the 5th, 2025 at 2:30. March 5th, 2025 at 2:30. And at that time, we will also take up Mr. Sandoval's case. Court makes no orders as to Mr. Sandoval today. However, Mr. Sandoval, you are here. So I'm going to ask you if you are willing to enter an appearance in this case, meaning the department doesn't have to continue to try to serve you. Are you willing to enter an appearance today?
I'm sorry, one more time. What does that mean?
It means that you've appeared in this case and that the department is not going to try to serve you with papers anymore.
Okay.
Do you agree to that?
Yes.
Okay. I'll find that you've made an appearance, but I'm not going to enter any other orders as to you today. Miss Ortiz, do you have any ability to pay for an attorney out of your own pocket in this case?
Currently, no, I do not.
All right. You don't have anything saved up, anything you can sell, anything like that?
Yes.
You do have something you can sell, or you do have money saved for an attorney?
I do have some saved up, and I could work something out with my colleagues and my boss.
All right. Now, let me ask you this question. Do you receive any type of governmental assistance at this time?
Just SNAP benefits for my children.
All right. Do you believe that if you weren't able to ask people to help you, or if you weren't required to use your savings, would you be able to afford an attorney at this time?
Maybe.
Maybe?
Yeah, probably.
Okay.
Most likely, yeah.
All right. What I'm going to do today is I'm going to maintain your indigency finding and allow Mr. Rudkin to continue to represent you, but I'm going to take this up at the status hearing. So what I want you to do is when you come to the status hearing, I want you to come prepared with your financials.
Okay, absolutely.
And I want you to take a really good look at what you have, and I want you to talk to an attorney or two and find out if you'd be able to afford their services. Because if you can't afford their services for the next year, then you would be considered indigent for the purposes of this case.
Okay.
So I need you to make an honest assessment of whether or not you'd be able to do that by March the 5th. Okay?
Absolutely. Yes, sir.
Same for you, Mr. Sandoval. Are you able to afford an attorney to represent you at this time?
No, sir.
Do you have anything saved up or anything you could sell that would enable you the opportunity to pay for one?
I could possibly talk to my colleagues and my boss.
All right. Well, I'm going to give you the same order. I'm going to fine you indigent today, but come on March 5th and let me know whether or not you'd be able to do it.
Yes,
Come
sir.
prepared with your financials.
Yes, sir.
All right. I have to admonish the parents that the state of Texas gives parents in CPS cases 12 months to demonstrate you can provide a safe, stable, violence and drug-free home for your child. In the event you cannot demonstrate that, your rights to your child are subject to restriction and or termination. Ms. Thompson, if you could make sure that the order includes, or whoever the assistant knows all this, the statutory language regarding removals. Ms. Peterman testified to it, and I'm making those findings. I'm just not going to repeat it all. Again, we'll be back March 5th, 2025 at 2:30, and that's when we will take up the status hearing in Mr. Sandoval's case. In the meantime, if you talk to your attorney and you decide to enter into this agreement, I don't have any problem with the parties exchanging an order and signing it, and we'll just prove it up that day and enter it that day. Okay?
Yes, sir.
All right.
Yes, sir.
Thank you all for your time and your service. If nothing further, all parties are excused.
Thank you.
Thank you.
Thank you,
You're welcome.
Judge.